Items for pronouncement of judgment. Item number 1, WPC 6331 of 2022.
Petition allowed.
Oblige your lordship. Item number 2, RSA 39 of 2025.
RSA dismiss.
Number 49, WPC 3239 of 2014.
Petition dismiss.
Wait, please, Lordship, I would like to mention item number 48 with the consent of other side, Lordship.
Lordship, a date may be fixed.
Yes, Lordship, June 19, Lordship. I have already talked to Panchali Bhattacharya. 19 days. 19.
Ms. R.D. Mozumdar, learned counsel for the respondent number 1. With consent from the other side, press for listing the matter on
19 June, Lordship.
19th of June. Okay.
Highly obliged, Lordship. Another matter I want to mention for listing on Thursday, Lordship, because in the last Lok Adalat, in the trial court itself, the case was settled. So we would like to withdraw the appeal, Lordship. Highly obliged.
Your Lordship, I would like to mention item 45 of the daily list. Your Lordship, this is an IA for withdrawal and we'll be filing our objection today. So the matter may be taken up with objection. We have taken consent from the other side also, Your Lordship.
I appear for the other side, Lordship.
When can it be listed?
Sorry, Your Lordship.
When?
Your Lordship,
Monday, Lordship.
next Monday, Your Lordship.
Next Monday?
Yes.
Okay. Miss, your good name, please?
A. Biani.
A. Biani, learned counsel for the respondent.
Yes, respondent.
Opposite number 1, Lordship.
Opposite, but the respondent in the IA, Your Lordship.
In IA.
In IA, I am the respondent and appellant in the.
Respondent with consent from the other side, press for listing the matter on next Monday. Parallel.
On 26th.
Wait, please. May I pray for listing of this MFA, my lord? Here, my lord, one of the respondent died, my lord. Can it be taken up on Monday, my lord, for orders, my lord? One MSc appeal, my lord, it was last listed in the month of June last year, my lord. Can it be listed next week, my lord, any day, my lord? My lord.
On 29th.
My lord.
I pray for listing of a substitution petition, my lord. It's filed in September of last year. It's not listed yet. It's some urgency. In
When
that.
do you want?
Not any date. Next week also.
Next week.
27th.
Listing of MAC appeal for admission, my lord.
When?
This Friday? Or, well,
Not
obliged.
Friday
Or Monday, my lord.
Monday.
Monday.
Monday. Obliged.
I am praying for listing of this matter next Monday.
May I please, your Lordship? I beg to mention for listing ISA, Lordship.
When?
22nd, Lordship.
Lordship, not this week. Next week.
Then,
Next
Lordship, 3rd of April.
Third of?
April.
3rd of June.
June. Sorry.
Okay. Okay.
2 application, Lordship. Much of it.
I would like to mention item number 23, Lordship. The learned counsel is out of station today. Kindly case may be list on June 30, Lordship.
23.
Item number 23, Lordship.
Okay. Mr.
S. Ahmed.
S.
Is out
Ahmed.
of station. I am on behalf of S. Ahmed. My name is M. Rahman.
M. Ahmed.
M. Rahman, Lordship.
M. Rahman, learned counsel, appearing on behalf of Mr. S. Ahmed, learned counsel for the appellant. Press for listing the matter on
June 30, Lordship.
June 30. Okay.
30th June.
30 June, 30.
30th June is vacation.
Then before 30 June.
27 June.
Lordship. Obliged.
May I please, Your Lordship? I beg to mention for item number 6. My senior has some personal difficulties today, so kindly adjourn the matter.
Miss,
He does.
learned counsel, appearing on behalf of Mr.
G. Bashir.
J. Bashir, learned conducting counsel for the petitioner. Press for listing the matter after a week.
Yes, sir.
There.
I will oblige.
Yes.
My lord, I have 2 RSA, my lord. Several times these 2 RSA were left over, my lord, for several occasions. So, my lord, may I pray on Thursday, my lord,
No.
if you lordship, my lord.
Next week.
Next week, any date may be fixed.
Under which column? Under which column?
Under hearing column.
On 3rd June.
3rd June. Obliged.
Please, Your Lordship. I beg for listing a read petition regarding education matter on Monday.
Great petition in senior court. Not before this. Okay.
May it be please your lordship. Lordship, I beg to mention one listing MFA for hearing column. Lordship, it's a old pending matter in the year of 2016. Lordship, matter may be listed on 5th of June.
Okay.
Obliged, your lordship.
Mayor, Your Lordship, here in this case, Your Lordship has already heard the matter B1 bail application on 14th, Lordship, and the final outcome is still awaiting. So if Your Lordship permits, so I have prepared one written argument, only concise point of my argument, Lordship, that if Your Lordship permits, I can place before Your Lordship. I have informed the PT also, I will give a copy to him also, if required.
So, we will not accept any paper from any party in absence of the other party.
No, I have informed, he is here, Lordship. He is here.
Acha.
I have informed him that I am making a mention before the honor.
You take copy to him
Lordship, I'll-
because he may file objection also.
Lordship.
Okay.
For motion, bail application, item number 3.
May it please, your Lordship. Lordship, in this case, we have taken the plea, my lord, that ground of arrest was not furnished. But I have also annexed the notice, my lord, that is page 34. Page 32, my lord.
Same Dhuburi PS case, my lord. Similar other matters fixed tomorrow, my lord.
Tomorrow, my lord, tomorrow, item number 5, BA number 174, 2025. Scan copy is there, my lord.
Before this court.
Before this court.
Okay. Heard Mr. Khandekar, learned counsel for the accused. This application under section 483 of the BNSS 2023 is prepared by accused. What is the name? Rafiqul Haq, alias Mirazul Haq, who has been languishing in Jailazut in connection with special case number 41 of 2024 under section 22 C. Stroke 29 of NDPS Act arising out of Dhuburi PS case number 345 of 2023 under section 22C of NDPS Act. Pending before the court of learned special judge to indicate additional Dhuburi or grant of bail. Mr. Khandekar, learned counsel for the accused submits that this is second or third.
Second one.
This is the second bail application preferred by the accused on the ground of non-communication of the ground of arrest to the accused in writing by the investigating officer, no, by the arresting authority at the time of his arrest. Mr. Khandekar further submits that similar matter is listed tomorrow as item number 5.
5,
As
BA
item
number
5.
1.
This matter may be also tagged with the aforesaid matter, being BA number
BA number 174 of 2025.
174 of 2024.
25.
Accordingly, taking note of the submission of Mr. Khandekar and also hearing Mr. Portaker learned additional PP, it is provided that recess the matter tomorrow along with PA numbers.
I'm deep.
Item number 4.
Wait, please.
Yes.
In this case, my lord, what has happened is that my petition under section 47 CPC taking certain objections which go to the root of the matter, they have that has been summarily rejected. But if your lordship will kindly have the first annexure, my lord, annexure 1 is page 15, my lord, 15. Lord,
No, you first tell me
lordship.
what is the power under section 47 of the CPC?
But as per a line of judgments, my lord, of the Supreme Court, the power is very restricted. It is microscopic in nature. But that does not mean, my lord, that the decree which has been passed without adjudicating, my lord, the right involved in the case of a dead person would also be, my lord, executed. Execution, my lord, it is appreciated, my lord. There is no doubt about that. Supreme Court has said it's a time, it must be completed within the, my lord, limited time frame. No doubt about that. But the fact of the matter is there are two issues here, my lord. One is that the co-pattadar was a dead person as on the date when
No, whether such kind of dispute can be adjudicated in a petition under section 47.
Look, if I can show prima facie that the co-pattadar who was made a party in the suit, my lords, as the defendant number 2.
Say, I'm giving you option to withdraw this petition, otherwise we will slap post.
No, lordship will.
You see, you submit later.
Item 5.
Kindly, Lordship, my senior is on legs in another court. Kindly pass over the matter for time being.
Okay.
Item 7.
None appears for the petitioner on call. Is the matter after.
Item 8.
May I please, your lordship?
Mhm.
My lord, Commissioner was appointed to record the evidence of the PW1 and PW2 also, my lord. And one opportunity was
How
also,
many occasion your
My
your
lord, kindly-
counsel remain absent?
my lord, my advocate was, along with the wife, was very serious.
So that's why I'm asking you, how many adjournment you have availed on that pretext?
Only two.
Two.
Only two, my lord. Kindly give me one, my lord, opportunity, and I will cross-examine. And my client has already changed the advocate also because he is 75 years old, my lord.
Hmm.
He is sometimes not coming to the court also because of the ailment. That is the only
Hmm.
prayer before your lordship. Order is dated 21/3/2025, reflecting at page number
Heard
40.
Mr. Sutter, learned counsel for the petitioner. In this petition under
227, my lord.
Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 21/3/2025 passed by the learned civil judge with indicate junior division Lakhimpur at North Lakhimpur in PS number 01 of 2024. It is to be noted here that by impugned order dated so the learned trial court has closed the cross-examination of the PW and thereafter fixed the case on 23rd/4/2025 for evidence of official witness. Mr. Sutter, learned counsel for the petitioner, submits that on account of illness of the wife of the earlier counsel of the petitioner, on two occasions, the witnesses could not be cross-examined by the petitioner. And he has already sensed the earlier counsel, and he may be given only one chance to cross-examine the witnesses. Having heard the submission of Mr. Sutter, I have carefully gone to the petition and the documents placed on record and also perused the impugned order dated 23rd/3/2025.
Cost is deposited, my lord. The subsequent order is the deposit of cost. 1,000 rupees cost was. It is at page number 49, my lord.
It appears that the learned trial court has fixed the case for cross-examination of PW on 16/1/2025, 17/1/2025, and 6/3/2025. But the petitioner herein failed to cross-examine them. And thereafter, the learned trial court has fixed the case on 19/3/2025 and 20/3/2025 and also imposed a cost of rupees 1,000. And thereafter, on account of failing to cross-examine the witnesses of the PW, the learned trial court has closed the cross-examination and fixed 23rd/4/2025 for evidence of official witnesses. Better taking note of the, it is to be noted here that right to fair trial is a fundamental right. And in fair trial, fair opportunities has to be afforded to both the parties. And right to cross-examination is also a legal right. And if the petitioner is not given fair opportunity to cross-examine the witnesses, then his right to fair trial will be affected. Taking note of the above, and also taking note of the submission of Mr. Sattar, learned counsel for the petitioner, and also in the given facts and circumstances on the record, this court is inclined to allow this petition the impugn order dated 23rd or 21/3/2025. So far, it relates to closing the examination of PW. Then set aside and was. Consequently, the learned trial court is directed to afford one opportunity to the petitioner to cross-examine the witnesses. In terms of above, this safety stands closed.
Obliged,
Item number 9.
obliged, your lord.
Make clear, your lordship. Here in this case, lordship, the opposite party respondents file a plan for declaration of right, lordship. And subsequently, they also file an injunction petition, which was rejected, lordship. And thereafter, lordship, they again file another application, lordship, for temporary injunction, lordship. And when they fail to get any order from the court, lordship, then they file a application for withdrawal of the suit. That your lordship will find at page 80. This application was rejected, that your lordship will find at page 16. And thereafter, lordship, they file another application, lordship, under section 151 of CPC, that your lordship will find page 85. In this case, lordship, the learned trial court reconsidered the aspects, lordship, and allowed the plaintiff to withdraw the suit with liberty to file a fresh, lordship. And being aggrieved by that, I'm before your lordship. This is the application at page 85 filed by them.
No. Learned trial court has granted liberty to the respondent to approach the court again by filing.
No, that
Appropriate,
impugn order, your lordship will find at page 94, lordship. Impugn order, page 94. After rejection of first application for withdrawal, the second application was filed, and then the impugn order was filed. Page 94.
So what wrong with the order?
Here in this case, my humble submission is that if your lordship peruses the application, that page 85 starts from page 85. I'm I'm placing lordship page 87. Paragraph 5, they have relied on a judgment of lordship Odisha High Court that the formal defects and sufficient grounds that has to be taken separately, lordship. And in this regard, lordship, our High Court judgment is there, which says, lordship, that sufficient ground has to be read along with that formal defect. So that judgment I'm just placing before your lordship, our High Court judgment. That was not.
Which is the relevant paragraph?
It starts from paragraph 5, lordship. That is the background of incorporation of that order 23 rule 1, lordship. And I'm relying on last paragraph, page 4, lordship, last part. Paging nation is down below, lordship. Left hand side, down below. What is apparent from may I read?
Hmm. And in which paragraph the learned trial court has
If your
Survey?
lordship see page 87 of their application, paragraph 10, last,
no, in the impugn order.
in the impugn order, your lordship will find page 96.
Hmm.
Last line, I opine that careless, so this is the only regarding merit of the case, lordship. I opine that careless framing of plaint, that paragraph.
If cause of action is not disclosed, then is it not a formal defect?
No, apart from that, lordship will find that lunacy of plaintiff's father and uncles, those new facts they wanted to bring in record, lordship, that in the application itself, your lordship will find in their application.
Maybe they have categorically mentioned about the cause of action.
But while in the impugn order, lordship, that once liberty is granted, they have every right to bring in new facts also, because in the application they have said, for a moment, lordship, may kindly see page 88. It starts from page 87, last two line, lordship, 87, last two line. Now the plaintiff wants to submit that the previously filed plaint may not be capable of helping the court to decide the said title suit, and the plaintiff may be prejudiced of his rights. Also, the previously filed plaint does not disclose the cause of action. The previously filed plaint lacked proper valuation. The previously filed plaint does not disclose the state of mind as lunatic of the plaintiff's father, plaintiff's uncle, etc., on whose behalf 2 numbers of gift deeds had been made. The fact of destroying the plaintiff's paternal house, the fact of protest of various kinds, and many more, which the plaintiff will place before this honorable court in due course of time. Many more which the plaintiff will place. So they have changed they will change the entire their claim.
Then
also.
you will get a chance to raise objection before the trial court.
In
That
fact,
is that-
in fact, if your lordship peruses the impugn order, page 95, on that day, one adjournment petition was filed by the senior engaged counsel, lordship. That page 94, your lordship will find. First paragraph. And in fact, this is the first time they sought for adjournment. In page 93, your lordship will find the previous order. On that day, they filed their objection, and that was the first date when they sought for adjournment. After hearing the petitioner side only, that the impugn order was passed.
Oh, the new suit, they have yet to be, new suit is yet to be filed by the opposite
As
party.
per my instruction, lordship, they have already filed. Recently, after filing this case, I have received the summons, lordship, the copy of that summons. And that is entirely.
You show me the plaint
Lordship.
where new facts are brought in.
New facts are brought. There are plain to liaison. In fact, in the present plaint, lordship, they have stated about two katha, 5 lessons, but in the present new suit, they have claimed more lands, lordship.
No, where they have pleaded the fact of lunacy.
No, they have not stated in their plaint. Only in the new, when they file application for withdrawal of the suit, then only they have brought the new facts.
Okay, we will examine the matter and we will pass the order.
Lordship.
Standing under
All
4.
right.
So the execution matter is fixed on 27. So let me make an attempt to satisfy your lordship.
Pardon?
The execution matter in the lower court, my lord, is fixed on 27th. So I have to make an attempt to satisfy your lordship, my lord, regardless of whatever. my lord. So let me, my lord, address the facts. Then of course it is up to your lordship.
No, I have already gone through the same.
Lordship.
I have also gone through the order.
Yes, my lord, the order, even at the time when we filed the petition, my lord, we were not aware, because lordship will kindly consider one aspect of the matter. The co-pattadar was, my lord, made a party in the
No, you tell me whether such matter can be adjudicated in a petition under.
My lord, if the decree, my lord, the decree if rendered a nullity by the death of the co-pattadar, my lord, but the co-pattadar was dead not after filing of the suit, my lord, he was dead on the date the suit was filed. The suit was filed in the year 2000, my lord, and the co-pattadar had expired in 1994. That is the, my lord's illegality which has tainted the decree, my lord. That will vitiate the decree, my lord. That is why, my lord, lordship will find that the page 15, what you will find that the co-pattadar was very much made a party, my lord. Because one land, my lord, 2 pattadars, and he has got a decree in respect of the entire land. I am only in possession of that 6 lessers odd, which is the schedule B part. But this co-pattadar, who was made a party as the defendant number 2, on the date when the suit was filed, he had been dead for 6 years. And this we have just come to know a few days back. Because the co-pattadar does not reside himself on the land. It used to be a vacant land, my lord, at that point of time. Lord, the lordship will kindly have, my lord, the death certificate which we have annexed at page 76A.
$70?
76A, my lord, annexure 12. Now, this is the death certificate of the defendant number 2, who, my lord, was the co-pattadar of the land, is the co-pattadar, my lord, even as per the latest Jamabandi, Abdul Qayyum, son of Abdul Latif, permanent address, SS Road, Fancy Bazaar, so-and-so, date of death, my lord, 19 June 1994. 6 years before the, my lord, suit was filed. And because this person did not used to reside on that land, my lord, nobody was aware. Maybe the plaintiff was aware or not, my lord, we cannot say. But the fact is that the entire suit land comprises of 2 katha, 10 lessers, as per the records which were then existing.
But
Now,
against the judgment and decree of the trial court, you have filed appeal and the
I have
appeal
filed
was
appeal.
dismissed.
Appeal was dismissed, RSA, and even in the RSA, my lord, I have also made Abdul Qayyum, this person, a party, because nobody was aware, my lord. Perhaps even the plaintiff himself was not aware. So, my lord, even up to the RSA order, lordship will find the RSA order, which is at page 53. Well, these things were not discussed because these things have just come to light. Well, page 53, lordship will find, this is the RSA order, 12/3/2024. I am the appellant, and it is versus Muhammad Mashar Ali Ahmed and 8 others. all the persons who were party in the suit, all of them were made a party. But as on date, this particular pattadar, who is admittedly the co-pattadar, he was dead. And he has been dead since 1994. His death, my lord, renders, my lord, the very judgment and decree in the suit a nullity. And therefore, everything that follows, my lord, has to go as a nullity. Now, if your lordship will kindly permit, my lord, page 21. Page 21, which is the para 12. The plaintiff says that the plaintiff has impleaded the pattadars of the suit patta number 206 as pro forma defendants in the above noted suit. But the plaintiff has not sought for any relief against them. But if the defendant or any one of them contests the suit of the plaintiff, they or they be treated as a main defendant and decree be passed against them. Now the man was dead, my lord. There is no question of his coming to the court and doing anything, my lord. Now, if your lordship will see, my lord, now page 68, my lord, which is the periodic patta, which was exhibited as the exhibit number 2 by the plaintiff himself. This is the own document of the plaintiff. Well, this is the periodic patta, and this, my lord, is of the year 2001 also.
Page number?
Page number 68, my lord, the Assamese version. Look, page number 68, this is the old patta number 206, new 36, and there are two pattadas. One is Abdul Qayyum, and the other is Masir Ali Ahmed, who happens to be the plaintiff, in other words, the respondent herein. And this position was as of 2001. This is the own exhibited document of the plaintiff. I am not saying that I have any case perhaps against the original plaintiff as far as these things are concerned, but this is a fact that he was the co-pattadar. Now, if there are two pattadars, how can the 2 Katha 10 Lesa belong to the plaintiff decree holder? And lordship will also find that I have given the latest Jamabandi.
No, that's all right. But decree was passed for?
Decree was passed for 2 Katha 10 Lesas.
That execution will be for?
That is the issue. Lordship will kindly have the page 69A, the annexure 10. That is the latest position. This is the latest Jamabandi. And still bears the name of the co-pattadar. Annexure 10, page 69A, my lord. This is the patta number 207. And the two names are still there. But if your lordship notices, my lord, the area of the land has somehow come down. Instead of 2 Katha 10 Lesa, it is now 2 Katha 5.34. But how and where this balanced land has gone and what happened, my lord, to this? Because, my lord, both of them cannot be owner of 2 Katha 10 Lesas. And if that be so, then the decree has to be treated as an inexecutable without deciding the interest of Abdul Qayyum. How could the decree proceed? He was dead 6 years. Okay.
We'll pass the order.
Lodge. Public.
Admission item 10, parted matter.
Met please, Lordship. Lordship, order dated 23/4/2025 may kindly be paid to Lordship.
Dated?
23/4/2025.
Yes.
Second paragraph. Pursuant to this court order dated 22/4/2025, Mr. Fupon and Mr. Choliha, I apprise this court that file number so and so is now pending in the finance department, and the finance department is verifying the matter and will complete the entire process within 2 weeks from, and therefore prays for listing the matter after 2 weeks.
Yes, anybody from finance department?
Mr. Soliha was appearing.
Pardon?
Mr. A. Soliha was appearing.
Lordship, Mr. HLA is not available today due to medical reasons, Your Lordship. Lordship, regarding the proposal, we seek some time to take instructions, Your Lordship.
Soliha is present in the court today.
No, Lordship, due to medical emergency, he is not present today in court, Your Lordship.
So you obtain the instruction in respect of this file number. You give the file number, we'll take it up at 2 o'clock.
Lordship, in the meantime, Lordship, last occasion, your Lordship was pleased to direct Mr. Goswami to obtain instruction regarding the judicial department concurrence.
Yes, Mr. Goswami, any information available?
I received, Lordship. Lordship, the said file was back, Lordship, sent back to the concerned department and advising to comply with the direction of this honorable court.
Okay. Mr. Yes.
I have also got my instructions today, madam. I have, I'm preparing for the elementary education. And my instructions are, can you see? Reference, I'm directing to that the department has re-endorsed the concerned file number so and so to finance department. So as soon as we receive the file from the judicial department, we have re-endorsed it and sent it to the finance department on 17/5/25 along with the views of the judicial department. Once again, seeking concurrence for the payment of salary as directed by the Honorable Guwahati. So we have complied and sent it to the finance department for concurrence. Now the file.
Okay.
Pairing number.
Yes, madam, may you obtain an instruction? We'll take it up at 2 o'clock.
Lordship, can we have it tomorrow, your Lordship?
Tomorrow?
Yes, your Lordship.
Why not today?
It will be difficult because Mr. HLA is not there. He's handling the matter, so I'll have to coordinate with him, your Lordship.
Let it be tomorrow then. Huh? Or Mr.
I am R. Islam.
Pardon?
R. Islam.
R. Islam, Learned Counsel for the Petitioner. And also our Mr. A. Popal, Learned Standing Counsel for the Elementary Education Department. And Mr. J.K. Goswami, Learned Additional Senior Government Advocate. And also heard Miss Borua for Finance Department. On the pairing made by Ms. Borua, Learned Standing Counsel for the Finance Department. Recess and list the matter tomorrow.
Lordship, there's an interim order there. There's an interim order.
Pardon?
Interim order is there that may kind.
Interim order pass earlier self-contained.
Lordship.
Item 12, order matter. Item 12.
Please, your Lordship. Lordship, as per last order, Mr. Khatuni was supposed to file an affidavit.
Yes, anybody from Elementary Education Department?
Secondary, Lordship.
Secondary. Mr. Pukan? Is Mr. Khatuni available in the court today?
My lord, I'll find out, my lord. Find out and
Kindly inform him.
inform him. Matter will come up sometime.
After some time.
My lord.
13 to 15.
May I please?
Yes.
In this case, the petitioner that is the plaintiff is an institutions, that is the college, your lordship, DHSK Commerce College. So there are 14 defendants in that case. And notice was served to all the defendants. But
Sir, Gupta, you have a defendant number?
My lord, in item number 13, I am for respondent number.
respondent of 4, 7 and 9.
Item number 39 for 1, 4, 5, 7 and 9. 4, 5, 6, 7, 9.
4, 5, 6, 7.
4, 5, 6, 7, 9.
So
He is not for the respondent number one.
Rest are performer respondent.
Yes, my lord, what happened, my lord, the order was one single, the judgment was passed ex parte. And my lord, thereafter, different three mistake cases were filed under order 9 rule 13, my lord. So that's why the three different revisions.
Three different, there are.
But
They
the
have-
order was common, my lord, one single order, ex parte order.
Title sheet was one. So the ex parte order is one. But the appeal has not been preferred by many other defendants. Only these three defendants, there is three cases, so 3 or 4 defendants have filed appeal. Before that, they have filed for vacating the ex parte order, and that was rejected. Now, basically here the question is that there.
No, Mr. Upadhyay, whether in absence of the other respondents, we can hear and dispose of the matter.
No, we have made the paper publication and already notice was served to your lordship. All because I have filed and the last order, your lordship, see the last order. Dusty service, we have taken the dusty service also, and later on we have served the.
So notice upon all the
respondents.
Sir,
Served, yes.
so what are the grounds?
Here the ground is that the appeal should not be allowed because we have taken the steps for serving the notice to them in various ways. And lastly, we have paper publication also. There is a paper publication in all these three cases. All these three cases, there is paper publication, and we have published.
For the trial court?
Yes, in the trial court. And as they didn't appear, the matter has been proceeded ex parte. And first, they have preferred this appellant, here this respondent has preferred an application for vacating the ex parte order to the trial court. And the trial court found that your lordship, come to the page 26. This is a trial court order.
Yes.
Today is fixed for the order on petition filed by the petitioners on order 9 rule 13 of the Code of Civil Procedures in order to vacate the ex parte decree passed by the court on 2/7/2009 entitled suit 3706. Here is the petition, heard the submission made by the learned counsel of the petitioner. The learned counsel for the petitioner submitted that the petitioner defendant is the lawful owner of the land measuring 1 kata 10 lesa, including in Dag number 262, KP Pata number 188 of Bairagi Mat Kasari Gaon, Moja Mankota in the district of Dibrugarh by means of possess by sale deed 1950. The petitioner has, after constructing his residential house, has been residing there with his family. The learned counsel for the petitioner stated that the petitioner was shocked to know from the title execution case number 10 2013 from Pranab Gogoi. The plaintiff OP title suit 37 had stated that the defendant petitioners had encroached from and out of the plaintiff's OP's land of 5 bigger. The learned counsel for the petitioner stated that the OP did not take proper step, which culminated into the passing of the ex parte decree by the court on 2/7/2009. The OP appeared and filed their written objections in relying the petition filed by the petitioner. The main contention put forth by the OP was that the summon entitled suit 37 was duly served upon the petitioner as per due procedure of law, as well as publication of the summon and the notice of missed case in newspaper Asame Pratidin on the issue 19/2/2008, and as such the question of non-service of summon upon the petitioner does not arise. During the proceeding, the petitioner Sri Kamal Chandra Gogoi was examined SPW1 and also cross-examined. He deposed in evidence that he did not receive any summon from the court pertaining titles 37/2006, and that he got know about the decree only from Pranab Gogoi. After the perusal of the petition and the written objection filed by the parties on careful consideration of submission made by the learned counsel of both the sides, it is almost important to first take up the statutory provision under which the said petition has been filed by the petitioner. Order 9 Rule 13 provide for setting up aside of a ex parte decree. The said provisions provide that if an ex parte decree is passed by the court against the defendant, he may apply for setting aside the said decree. It is mandatory for the court to set aside the ex parte order if defendant is able to satisfy the court that the summon was not served upon him or he was prevented by the other sufficient cause from appearing when the suit was called for hearing. The second provision, however, provides that no court shall set aside an ex parte decree merely on the ground that there has been an irregularities of service of summon if it is satisfied and defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim. Now let us see if the above provision can be applied in the background of the fact and circumstances in the instant case. Thus, the main questions which needs to be decided in the instant case, whether the summon was duly served upon the petitioner or whether he had knowledge about the title suit. Peruse the case record and after careful perusal of the case record, it appears that the summon on the petitioner was served, but he has refused to accept the same, and hence it was deemed as proper service by the court. And since he did not turn up, the case proceeded ex parte against him. The merit of the case are not relevant of consideration of deciding the application under the rule. From the perusal of the case record, it can be said that there was due service of summon on the petitioners from the statutory provision. It is clear that if the defendant is able to satisfy the court that the summon was not duly served upon him or he was prevented other sufficient cause from appearing, then the court is bound to set aside the ex parte order. However, in this case, the petitioner, through his petition as well as the evidence, could not satisfy the court that summoning was not served upon him. Then there is, on reference of the court order, it is true that the party should not be penalized for the situation which is beyond their control. The main emphasis is on being beyond the control, which does not seem to be seen here. Moreover, none of the statutory provision intend to encourage negligence, irresponsibility on the part of the party, which if encouraged and allowed would end up in causing breakdown of the entire justice administration system. Though the court should not take a hyper technical and rigid approach when the rights of the parties are concerned, but too much of the casual and liberal approach towards the procedures without sufficient and just reasons. To do so would cultivate chaotic atmosphere in the judicial system, leading to multiple litigation and finally lead to a judicial. Keeping all the above in mind, the petition of the petitioner stand rejected. After satisfaction, the trial court has rejected the ex parte vacating petition. And he preferred the appeal, and appeal was allowed, your lordship. The impugn order is page 34, 35. The relevant paragraph is 10, page 38. Your lordship.
So, can it be said that the process server has served the summon as per order 5 rule 17 CPC?
No, your lordship, we have taken the proper step. And if your lordship need the entire record, the service of the report, then the LCR is necessary.
No, no.
But-
Going by
but-
the
But so far there is
judgment of
a
the appellate court,
appellate court has,
especially
Eh.
in the discussion in paragraph number 10,
yes,
can it be said that the process server has served the summon
there-
as per procedure?
in this case, the appellate court doesn't refer the paper publications.
Pardon?
paper publication, there was a paper publication also.
Hmm.
So that has not been referred here.
Whether the trial court has referred to the same.
Yes, earlier I have given it. And in the next two cases, the appellate court has referred that there is a paper publication. So when there is a paper publication, your lordship, anything else remain. And if your lordship need to prove, then LCR is necessary, your lordship.
Sorry to interrupt, my lord. In this first item, my lord, in this, there is no paper publication, my lord. In page 38, my lord, paragraph 8.
No, yes, that has not been mentioned, but there is a paper publication because at the time of paper publication, we published for all the
Yes,
all the
trial
defendants.
court has mentioned it in the order.
Yes, trial
It was
court has-
published in Ohomia
Yes.
proceeding.
Yes, ma'am.
Yes,
But in
Trial court has
in the
mentioned.
that is there, my lord, but in the appellate court judgment, my lord, page 38, paragraph 8, appellate
Yeah.
court says, my lord, although 5 attempts were made, then after, my lord, but since, my lord, paragraph 8, my lord, page 38, paragraph 8.
It is there, your lordship, but there is a paper publication. And in the next two cases, the appellate court has said so. There is a publication, paper publication.
Even then, it has allowed the appeal.
Yes. Even then, that decree passed by the trial court was set aside.
Yes, what is your submission?
My lord, with regard to first, my lord, that is CRP number 188, 2018. My lord, although the trial court has referred that there is paper publication, but from the appellate court, it appears that, my lord, there is no paper publication, my lord. Here, my lord, in paragraph 8, it says, my lord, 5 attempts were made to serve the summons, but he could not exceed. On 3 occasions, defendant refused to accept summons. And my lord, on 1 occasion, house of the defendant not found.
No. Appellate court has failed to take into account of this observation made by the trial court.
My lord,
Appellate court has failed to take note
Yes,
of the observation made by the trial court that it was published in the paper.
yes.
my lord, trial court says so, but appellate court judgment does not say that there is any paper policy. So, my lord,
Maybe, therefore, that judgment is liable to be set aside.
my lord, let it be then record be called for, my lord, that it will be better, my lord, because I have the instruction that in 2 cases there are paper publication, my lord. In 1 case, there is no paper publication, my lord. Other 2, there are paper publications, my lord.
But in generally, when we go for the paper publication, in 1 case, there would be 1 publication for all the defendant who didn't appear. So in this way, on 9/2/2010, we have the paper publication.
And my lord,
We have given
with regard to paper publication also, my lord, the criteria of Order 5 Rule 20 has to be satisfied, my lord. That the defendant is avoiding the service of the summons, my lord. Then only the court can go for Order 5 Rule 20, my lord.
So the defendant has refused to accept the summons.
My lord,
There
if-
is observation of the trial court.
My lord, if that be so, then my lord, Order 5 Rule 17 says, my lord, that paper, then the summon along with the plaint should be pasted on the address which is given in the plaint, my lord. That is not there. And even, my lord, the process server was not examined on oath, my lord. And no witnesses were cited to show that he went to serve the summons, but it was
That's all right,
refused, my lord.
but why should we ignore the paper publication?
My lord, for paper publication, my lord, first, my lord, Order 5 Rule 20 says, my lord, that the court must have to satisfy that the defendant is avoiding the service, my lord. If the court comes to that finding, then only, my lord, Order 5 Rule 20 will come, my lord. That is of substituted service, my lord.
If it's so, then there is no meaning of the paper publication, your lordship. And here too, we have published the paper because some respondent didn't appear.
But the entire, but the order for expertise flows from the order 9 rule 6. So there the court satisfaction that the summons has been duly served. That should be there. And how the summons are duly served, that will again go back to the order 5, the procedure prescribed under order 5 in the instant case, the rule 17. And also rule 20. And the under order 9 rule 13, the court only the satisfaction the court should have whether the notices were duly served. So appellate court has found, my lord, that it was not duly served. So therefore, my lord, the entire the order, my lord, passing expertise have been set aside. And after all, my lord, it's a procedure, my lord, is the handmaid of justice, my lord. Why they are insisting for the my lord, expertise when, my lord, there is no clear finding. So far, the order, my lord, by which the court have passed to proceed this expertise doesn't indicate anything. But those orders are not made part of this revision petition. So therefore, it could not be the order by which the court has ordered for proceeding expertise, that is order 9 rule 6, the order passed under order 9 rule 6. When defendant doesn't.
Yes, you have not
annexed those.
record that order.
Yes.
So
That has not been annexed, yes.
that's the main the issue,
But let the record come there.
Yes.
Heard Mr. Whitehead, learned counsel for the petitioner, and also heard Mr. Tejas Vikia, learned senior counsel, assisted by Mr. Gupta, learned counsel for the respondent. Respondent number?
Respondent number 1, 4, 5, 6, and 9.
1, 4,
5, 6, and 9.
5, 6, and 9. 5, 6, and 9. After hearing learned counsel for both the parties, perusal of the record is found to be necessary, and accordingly it is provided that SSL call for the record of what is the number of the case?
PS
number
37, 2006.
PS 37 of 2006 from the Court of Learned. Concept number
Municipal number 2.
2. Concept number 2, Dibugar. List the matter after 2 weeks. After 2 weeks.
Perhaps it is concept number 1.
Yes.
All the 3 matters?
No,
No,
title
the
suit number
misca-
is same,
No,
but
no.
by different order, expertise has been proceeded against different defendants. So therefore, the 3.
All the 3 is similar, your lordship.
So one stage of same record.
Yes.
Same case.
Record is same.
Same record.
Record is same. But in
Let the
others,
record come then.
in others, we are representing different respondents.
Mr. Gupta, you give the list to Court Master.
Only in this case, one confusion is there. The Miss J case was, Miss J case, or the ex parte vacating petition was heard by the Munsib number 2. But the original case was heard by the Munsib number 1. So from the court of Munsib,
Okay, Court of Concept.
Yes. otherwise there will be confusion.
Timing item 12.
Today I will file the affidavit. Today I will file the affidavit.
Today?
Today, my lord.
Okay. Heard Mr. Monto, learned counsel for the petitioner, and Mr. N.J. Catonier, learned standing counsel for the Secretary Education Department. Mr. Catonier submits that he will be filing the affidavit in opposition during the course of the day. Accordingly, it is provided that SSL is the matter enclosing the affidavit in opposition after 2 weeks, enclosing the affidavit in opposition.
That may be fixed also as part of matter.
As part of.
Timing item 5.
Meanwhile,
Take a date from.
yes, your lordship. And meanwhile, I shall file my objection to it. If something I have, I will file my.
Mr. Monto may file his objection. No, he's reply to the affidavit in opposition filed by Mr. Catonier.
Deeply obliged.
Timing item 5.
Lord, the impugn order is at page, page 48, annexure 3, my lord. This petition was filed, an application was filed under order 7 rule 11 because it was barred on the part of the civil court. The matter was squarely covered under the regulation of the Assam Land Revenue Regulation. Here in this case, my lord, the plaintiff challenged the order of the circle officer, which is applicable to the revenue authority. And there is a good number of judgments.
No, he also paid for right title and interest and.
But the right title interest, that right title interest depends upon the that Namdari. Because if Namdari is not cancelled, right?
Let notice go at this.
My lord, the record may be kind of called for because I have brought the judgment of the High Court that even though, my lord, that judgment has been overlooked and the judgment which is referred by the learned trial court, it is judgment of the my lord, which is not applicable in the present case. That was the question always regarding that case, my lord, which is referred. Anyway, my lord, record may be kind of called for because it's very urgent.
R.C. Sakia, learned senior counsel assisted by Miss. Learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated.
That is 21-25, madam.
Dated 21.
20 January 25.
21/2025.
In Miss case number 457 of 22, madam.
Passed by the learned.
Learned
Civil Judge Junior Division number
4, madam. Yes, lord.
In Miss case number 457 of 2022, arising out of title suit number 26 of 2022.
My lord.
There is a petition and the documentation records. Let notice be issued to the respondents returnable in 4 weeks. That be taken by registered post with ADN also by usual process within a week from today.
That shall be necessary because the learned trial could have overlooked the statement made by me. That is why else shall be necessary, madam.
SSL call for the scan copy of the record from the learned trial court. Fix the matter after 4 weeks. Step be taken forward.
Obliged, madam. Much obliged. Lordship.
16.
The lordship, my lord, it's a regular first appeal, my lord, against the judgment and decree dated 5/10/2024 in TS number 18/2022 passed by the learned civil judge senior division Hailakande, allowing the decree for specific performance of the content. So this, by humble submission, my lord, taken all down, my lord, the tax issue in this case, my lord. Out of the total consideration amount of 34,400,000, my lord, my humble submission is he paid rupees 4 lakh. And subsequently, all these Bainama, my lord, each time I paid him, he paid me advance, he manufactured those things, my lord. Apart from other things, that is the main ground, which has come in the finding of the court below also. But court has also taken the ground that I did not adduce any evidence to prove it. But otherwise, court has come to the conclusion, my lord, that the discrepancies are there in the legit, my lord. Apart from other legal ground, my lord. My grounds, my lord, it may be admitted, my lord, as a regular first appeal. My memo of appeal ground starts at page 8, my lord. And the relevant ground, my lord, E and F, my lord.
Heard this, sir, is totally learned counsel for the petitioner, for the appellant. This regular first appeal is directed against the judgment and or decree dated 5th of October 2024, passed by the learned civil judge senior division Hailakande in Title suit number 18 of 2022. Is to be noted here that by the impugned judgment and decree dated so and so the learned trial court has decreed the suit of the plaintiff. Where is the memo of appeal and the grounds mentioned therein? And also where is the impugned judgment and decree dated 5th of October 2024? Admit. Issue notice to the respondent.
My lord, the respondent actually appeared, they filed caveat, my lord, they said. Oh, no, formal notice may not be necessary.
I am appearing lordship, caveat already filed lordship. Okay. However, no formal notice is required to be so since Ms. R. Sodori learned counsel for the respondent entered appearance and accepted notice. But extra requisite copy of the petition be furnished to her. The copy of the memo of appeal be furnished to her during the course of the day. Registration call for the record. List the matter after for it.
I am, my lord. Under order 41 rule 5, my lord. They file execution case, my lord.
Only lordship, already execution proceeding initiated and we are ready to pay the amount and next date is fixed on 22nd May, lordship. Only lordship, endeavor should be made upon receipt of the LCR to dispose of the matter.
Yes.
Lordship. Pardon? Endeavor should be made after receipt of the LCR to dispose of the matter, lordship. Already we have executed the sale deed already prepared and amount is to be deposited next date 22/5, lordship. Rest of the amount, lordship. Out of 34 lakhs, we have already paid 21 lakhs 5,000, 50,000. Rest amount we are directed to pay that will be deposited on 22nd May, lordship.
My lord,
Yes.
that is disputing. Oh, yes, early hearing is no problem, my lord. The only thing, execution has to be stated. Because
Execution case number. The first appeal, lordship, I have nothing to say, only that.
yes, yes. Yes, for early hearing, no problem.
Heard Mr. A. Sodori, learned counsel for the petitioner and also heard Ms. R. Sodori, learned counsel for the respondent of the case number they have application under order 31 rule 5 of the CPC prepared by the applicant for staying operation of the judgment and decree dated 5/10/2024 passed in case number 18 of the 2022 by the learned civil judge senior division Highland County. It appears that in connected regulars, the connected regular first appeal has already been admitted for hearing. And the record has also been called for. And as such, taking note of the submission of learned counsel for both the parties, the impugned judgment and decree dated so and so state till disposal of the RFN number so and so. In terms of above, this IA stands closed.
Obliged.
Item number 17.
Right. This is the first appeal, my lords, against the dismissal of my suit for specific performance. My lord, the Senate court below has committed error, my lord, by holding that there is no valid and concluded contract. And my lords, the own finding of the learned trial court is that the witnesses have, and that too in ex parte matter, it was ex parte.
Heard Mr. Ganguly, learned counsel for the petitioner. No, for the appellate. This is regular first appeal under section 96 of the Code of Civil Procedure is directed against the judgment dated 22nd January 2025 and decree dated 6/2/2025. Passed in PS number 57 of 2023 by the learned Court of Civil Justice, Senior Division, Summit Court in Strasbourg. Whereas the memo of appeal and the grounds mentioned therein. Admit. Issue notice to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by legal process within a week from today. Places shall call for the record from the learned Civil Justice Senior Division, Summit Court. Record of PS number 57 of 2023 from the Court of Learned Civil Justice Senior Division, Summit Court, Dashboard. List the matter after 4 weeks.
So item number 18.
The liberty of my lord, in item number 4, I have hand over one judgment for your lordship's consideration in the item.
The petitioner has filed a divorce petition under section 10 of the Divorce Act, my lordship, but the land.
Bill under section 55 of the Divorce Act 1869. Indian Divorce Act 1869. As amended by Marriage Law, Amendment Act 2001. Against the judgment and decree dated 26/3/2025, passed in PS number TS D number 04 of 2022, passed by the learned district judge Udalguri. It is to be noted here that by the impugned judgment and decree so and so, the learned trial court has dismissed the suit filed by the appellant on contest. Where is the memo of appeal and the grounds mentioned there? Admit, issue notice to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. SSL call for the record from the learned trial court. Place the matter first 4 weeks.
Item 19.
And this is an appeal filed by the insurance company lordship. In this case, this was a school teacher lordship, and his family member is getting full salary as per the CFP scheme lordship. Compensation of family pension scheme lordship. His family member is getting full salary till the date of superannuation. So there is no loss of dependency. Only the claimant will be entitled.
Heard Mr. KK, what learned counsel for the appellant? This appeal under section 173 of the MD Act 1988 is directed against the judgment and award dated 1/3/2025, passed by the learned member MSCP Kamrup M in MSC case number. There are several members in Kamrup.
Yes, lordship.
Metropolitan District. Which member has passed this judgment?
Lordship, in this case, the MST2 lordship.
Okay, mention it in your
lordship in the page number 3.
title.
Page number 3 lordship.
Hospital learned member MSCT number 2 Kamrup F in MSC case number 222 of 2023. It is to be noted here that by the impugned judgment and award dated so and so, the learned member MSCT number 2 Kamrup M Guwahati has directed the appellant herein, the United India Insurance Company Limited, to pay a sum of rupees 64,48,768.60 rupees, being the compensation to the respondent number.
Respondent number 1, 2, 3.
1, 2, and 3.
1 and 2.
Respondent number 1 and 2. Respondent number 1 and 2. Where is the memo of appeal and the grounds mentioned therein? Admit. Issue notice to the respondents, returnable in 4 weeks, to be taken by registered post with AD and also by the process within a week from today. Place the matter after 4 weeks. I. 50%?
In this case, 20% lordship. In other cases also, we are depositing 20%.
Why 20%?
Lordship, the family member will be entitled only the future prospect amount, not more than that.
So that is yet to be decided.
Lordship, that is why lordship,
That is yet to be decided.
in other cases, lordship, we are depositing 20% lordship. Or notice may be issued lordship regarding a stay lordship.
Okay, then issue notice.
And item number lordship,
20.
Wait, please, your lordship. My lord, here we have two grounds in the appeal, my lord. First of all, the vehicle alleged to be involved was not involved because the GD entry, on the GD entry, had mentioned some other vehicle, then the vehicle proceeded against my lord. And secondly, my lord, the person was driving the vehicle, my lord, was not having driving license. So evidence was laid to that effect. That evidence was discarded and liability was fastened upon the insurance company.
Heard Mr. T. Coletta, learned counsel for the appellant. This appeal under section 173 of the FDA 1988 is directed against the judgment and award dated 6/2/2025, hospital learned member, motor accident claim tribunal number 2, Kamrup M. Guwahati, in MSC case number 60 of 2023. It's to be notated by the given judgment and award dated so the learned member. MSCT.
Number 2.
Number 2, Kamrup Guwahati, Kamrup M. Guwahati has directed the appellant hearing to pay the sum of rupees. What is the amount?
My lord. Well, it is, my lord.
20 lakhs 40,000.
20 lakhs 40,000. Page number 31.
20 lakhs 40,000 to the respondent number.
123.
Respondent number 123. Where is the memo available and the grounds mentioned therein? Admit issue notice to the respondent. However, no formal notice is required to be issued to the respondent number
1, 2, and 3.
1, 2, and 3.
Claimant.
Since Mr.
Petition.
AP Circle, learned counsel for the respondents, entered accredence and received notice. However, extra is a copy of the memo of appeal they furnished to him during the course of the day. Recessal call for the record from the learned tribunal. This is the matter of the proofs.
My lord, notice only in respect of respondent number 4, my lord. Notice.
There are correspondence.
4 respondents.
However, issue notice to the respondent number 4 by registered post with AD also during the process. Who is respondent number 4?
Owner cum driver. Owner cum rider.
In IA?
I have first day, my lord.
50%.
Lordship, we are ready to deposit 50% subject to furnishing a bond by them, my lord.
No, he has not paid for releasing it.
Lordship, I am praying for releasing Lordship. This order may be passed in the next appeal also. We are ready to Lordship execute the bond also.
Okay. Subject to payment of 50% of the awarded amount. Operation of the MPM judgment and award date expenses state. Mr. Before the registry of this court, Mr. Sarkar, learned counsel for the respondent number 1, 2, and 3 submits that the respondent number 1, 2, and 3 may be allowed to withdraw the aforesaid amount from the registry of this court. That is, Mr. Coletta submits that the respondent number 1, 2, and 3 may be directed to withdraw the amount on executing a bond. Mr. Sarkar submits that they are ready to execute one bond. Accordingly, it is provided that the amount deposited before the court shall be released, before the ratio of this court shall be released on executing a bond to the respondent number 1, 2, and 3. In terms of this, I stands closed.
21.
Much obliged.
Lordship, in this case also, this is was a state government employee of state of Assam, Lordship.
Okay. Heard Mr. K.K. Watt, learned counsel for the appellant. This appeal under section 173 of the MD Act is directed against the judgment and award dated 10/2/2025, passed by the learned member MSCT Golpara in MSC case number 166 of 2020. It is to be noted here that by the impugned judgment and award dated 10/2/2025, the learned member MSCT Golpara has directed the appellant herein to pay a sum of rupees 57,57,977, bring the compensation to the respondent number
1 to 3.
1 to 3. There is the memo of appeal and the grounds mentioned therein. Then also admit issue notice to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process within 1 week from today. List the matter of 4 weeks.
Record
I
may be
issue notice.
record may be called for.
For the
Appeal hearing 22.
Lordship, kindly allow for time.
Lordship, allow us 1 week time to file our objection, Lordship.
Any objection?
No.
Heard, Mr.
Cameraman.
Learned counsel for the accused and also heard Miss
And Kakoti, Lordship.
learned counsel appearing on behalf of Mr.
SCP.
SCKL learned standing counsel for NCB.
NCP, Lordship.
NCB. Ms. Kakoti submits that 1 week time may be granted to the NCB to file their objection. There is accordingly allowed. Process shall raise the matter on
Second.
Obliged, Lordship.
Must.
Attend 24. 24 and 25.
Order dated 8/5/2020. We have complied with the order, Lordship. This is the compliance order. The service of the Umar Ali Sheikh has been provincialized, Lordship, with effect from 1 to 2021.
It should be 1/1. It should be 1/1, Lordship.
Maybe that I'll have to check, Lordship. Typical maybe.
the post is yet to be created.
Lordship.
Post is yet to be created.
SIV approval finance is already given, Lordship.
No, there's a second paragraph. Implication has wrongly been calculated. Yes, Mr. Islam.
Lordship, firstly, Lordship, that is not complied with, Lordship. This honorable court directed to provide the provincialization benefit, Lordship. That has not been done, Lordship.
Benefit after first he has to be provincialized, then the Already there is the direct.
Effect from, with effect from,
Lordship,
yeah.
yes.
one Lordship,
One,
two thousand
1st of
twenty-one.
February 2021.
Yes, that
No, Lordship. Lordship, this honorable court, page 57 of my contempt petition may kindly be perused. Page 57. Fifth paragraph, Lordship. Accordingly, the date that is 1/2/2021 as appearing in the paragraph number 19 and 20 of the order dated 3/5/2024 passed in so and so is corrected, and accordingly the same be read as 1/1/2021. And we have also communicated the order.
Then that has to be corrected, Lordship. They're only 1 month. Then we'll issue the order. It's today itself, Lordship, correcting that word.
Today itself.
I will direct the DC. Let it taken about Wednesday or tomorrow or Wednesday. Whether that Lordship may fix.
Tomorrow.
Yes, tomorrow or Wednesday.
Tomorrow, Lordship.
Only that correct has to be.
Heard Mr. Islam, learned counsel for the.
Tomorrow I will not be available. Lordship, Wednesday, please. Only Wednesday. Yes, Wednesday. Yes.
And also heard Mr. Sisti for that contempt. Mr. Sisti submits that order of this court has been complied with. And they produce a letter of the secretary to the Government of Assam Department of School Education dated 19th of May 2025. When a copy of the letter dated so and so is furnished to Mr. Islam, learned counsel for the petitioner, Mr. Islam submits that this court is directed to give effect of the order from 1/1/2022, but in the letter dated 19th of May 2025, it has been indicated that the service of the petitioner has been provincialized with effect from 1/2/2021. At this instance, Mr. Sisti submits that he will place the corrected letter before this court on Wednesday and place for listening the matter on Wednesday. There is accordingly allowed recess and list the matter on Wednesday.
Oblige you.
Produced before the court to the subject part of the record.
Lordship, their writ petition, Lordship. Writ petition 3093, Lordship.
Yes.
Lordship, the order dated 9/8/2024 may kindly be perused, Lordship. My learned friend undertook to provincialize my service, Lordship.
I cannot undertake. I will take the
Lordship,
instruction. Lordship.
9/8, Lordship.
Lordship may both the cases taken up. Lordship may can take it up on Wednesday, Lordship.
Heard Mr. R. Islam, learned counsel for the petitioner, and also heard Mr. Sisti, learned dissenting counsel for the respondents in Secondary Education Department. Mr. Sisti, based on listening the matter on Wednesday, along with contempt case number
532.
532 of 24. Accordingly, it is provided that recessal is the matter on Wednesday, along with contempt case number 6.
Oblige you.
I'm obliged.
Twenty-six part heard.
Lordship, my senior is on leg.
Who is your senior?
Asif Iqbal. Iqbal.
Iqbal.
Yes.
In that case, let the matter come up day after tomorrow, Lordship.
Tomorrow?
Day after tomorrow.
Day after.
Your Lordship, this matter has been coming for orders for a long time. Let this matter come for admission hearing.
No, this is already a part third matter. Lordship has extensively heard it.
Yeah.
orders, matters of admission, those are not normally part heard. So it is a part heard matter, so day after tomorrow it may be sorted out.
As agreed by learned advocates of both the parties, recessal is the matter day after tomorrow.
Deeply, yes.
27.
The service is complete in this.
Service complete.
They have entered a petition. It will be fixed for hearing.
Pardon, Mr.
Wasim Haq for A sector.
Learned counsel for the petitioner and Mr.
I am J. Borua for the respondent. my
Jay
lord.
Borough for the respondent. Since service has already been completed, recessal is the matter for admission hearing on when
My lord, I had a small submission to make. Actually, this matter has been now almost resolved between both the parties. And we were original plaintiffs in the original commercial suit in Jorhat. Now the appellant here, who are the defendant, they have already paid us 2 installments. And the last installment is due on the month of June. The moment, my lord, we have paid that money, we have decided and agreed to withdraw the parent commercial suit in Jorhat. So that has already been decided between both the parties, my lord. Only 1 installment is remained to be received by us, to be paid by them in the month of June. They've already paid 2 installments.
then we'll list the matter in the month of June.
Oh, you're obliged. Okay.
Recessal is the matter on suggested date.
Anytime after June 7th, my lord, because that's the date.
June 7.
Anytime after that, because that is the date they are proposing to make the payments.
June 13th June.
Obliged.
28.
His wife has filed a petition for transfer of a case from Dhemaji to Tezpur Lordship. And in this case, the respondent and petitioner of the legally married wife of the respondent Lordship, they got married in the year 2016 Lordship. And thereafter, she was driven out in the year 2016. And the husband filed a divorce proceeding in the year 2023.
No, whether service completed or not.
Lordship,
Whether service completed or not.
16.5 office to there is 16.5 Lordship on the last 2 occasion Lordship, no service report has come Lordship. And the trial court proceeding is still on Lordship, and next date is 21/5 of 2025 Lordship. After 2 days Lordship. That is why I am pressing the facts Lordship. And wife has also filed a petition for maintenance in the Tezpur court Lordship. And husband filed a divorce
No,
proceeding.
you first service of notice upon the respondent.
Lordship, office noted at 16.5 Lordship, no service report has come on the last 2 occasion also.
Heard, Mr.
P. Haldar Lordship.
P. Elder learned counsel for the petitioner. Office note dated 16/5/2025 indicates that neither service report nor observed notice received back by the arrestee.
A short date may be given for that.
Accordingly, you want to take such a step or will await service report?
We'll wait for some time Lordship.
List the matter after 2 weeks awaiting service report upon the respondent number. Upon the respondent, sole respondent. So why you have not tried for staying the
Lordship, because
proceeding on the very first day?
Lordship, we have made him, we have prayed, but learned court was of the opinion that the stay will be considered after hearing the other side. Lordship. There is an observation in the first.
Okay, then today on what basis we can consider it?
Because
Service is yet to be
Lordship, on the next day, we immediately have taken step Lordship, and the 2 last and the on the address given in the divorce proceeding by the respondent Lordship. And on the last 2 occasions Lordship, no service report has come, and the trial court proceeding is still on Lordship. That is why I am
after 2 weeks. After 2 weeks.
Till then Lordship, the date may be fixed.
Had it been the first day, then we would have considered it. But on the first day, it was not considered.
So the date may be fixed then.
Okay.
On 2nd June. Item 29.
May I please your lordship? Lordship is a transfer proceedings. My lord, the service is awaited upon the respondents. But my lord, on last occasion when the matter was by your lordship has said a prayer for the interim will be considered on the next day. The service is awaited upon the respondents.
So first, let the other side appear.
Yes, my lord, because it is under fatal act. My lord. Yes, my lord.
What to do? You want to take fresh step?
My lord, we have on last occasion taken steps, so steps may be awaited. And my lord, can this matter be fixed on in the month of June? Because on 1st of July, it is before the lower court, learned court below. So my lord, can it be in the month of June, the next day?
Ordinance S. Maiboro, learned counsel for the petitioner. Office note dated 16/5/2025 indicates that service report upon the respondent number 427 is awaited or awaited. Mr. Gogoi for respondent number
1 and 3 lots.
1 and 3. How about Mr. Gogoi, learned government advocate for the respondent number 1 and 3 present. List the matter on
23rd, my lord.
3rd of June.
23rd.
23rd of June, awaiting service report upon the respondent number 427.
Item 30.
Wait, please, your lordship. Lordship, I have taken steps upon the respondent number 1. In fact, I have filed the dusty affidavit, my lord, today. I have the office copy, my lord. It was received on 16/5. So let the dusty affidavit come on record, my lord.
So day after tomorrow.
After. And the interim order, my lord. There is an interim order, my lord. That may be continued.
Third, Mr.
A Deca.
A Deca, learned counsel for the petitioner. Mr. Deca submits that after effecting service upon respondent number,
Sole respondent.
sole respondent by Dusty mode, he has filed an affidavit today in the section.
Yes.
But the said affidavit is not placed on record. Accordingly, it is provided that processor is the matter day after tomorrow, and closing the affidavit filed by the petitioner.
31.
Yes.
My lord, I do apologize for item number 29. Can I be permitted to take dusty mode of 29 in item number 29?
Okay. The learned counsel for the petitioner submits that she may be permitted to file service of notice upon the respondent number 427 by Dusty mode. Fair alone.
Oblige, my lord, highly.
31.
May I please, your lordship, this I for allowing the applicant number 1 to withdraw the amount of 50% which is deposited by the insurance company, lordship, as per the order dated, lordship, 3/3/25, lordship. I am annexing the order, lordship, as page 8, lordship. And as per the direction, lordship, they have deposited the amount, lordship, in the month of March, lordship. The 50% of the order amount.
Yes, madam, any objection?
No, yes, I have no.
Third, Mr.
Yeah, Bhagwan.
A. Barua, learned counsel for the applicant, and Ms.
P. Borthakur,
P. Borthakur,
appearing for opposite party appellant.
learned standing counsel for the opposite party number,
Opposite party appellant, your lordship.
opposite party from appellant. This interlocutory application is prepared by the applicant, namely,
Digvijay Mandal.
pardon?
Digvijay Mandal, lordship.
Digvijay Mandal and Srimati Parvati Mandal.
Yes.
For allowing them to withdraw 50% of the awarded amount deposited before the registry of this court person to order of this court dated 3rd of March 2025 in MSC appeal number in IA number, IA civil number 332 of 2024 arising out of MSC appeal number
566 of 202.
66 of
2024.
566 of 2024. Mr. Goro, learned counsel for the applicant submits that the appellant in MSC appeal number 566 of 2024, person to order passed by this court in IA civil number 332 of 2024 has deposited a sum of rupees
50% of the awarded amount.
What is the 50% amount?
Lordship,
50% of the awarded amount of rupees
11 lakhs.
23 lakhs.
23 lakhs 22,525.
That is the awarded amount.
Yes. And 50% of the awarded amount. And the applicant may be allowed to withdraw the aforementioned amount from the registry of this court. Ms. Portapur submits that she has no objection in the event of allowing this application. Further, taking note of the submission of learned counsel for both the parties, this IA stands allowed. The applicants are allowed to withdraw the 50% of the deposited amount before the registry of this court.
Master please.
32.
Makes speech a lot. Well, this is application for allowing to withdraw 50% of the awarded amount. But my lord, I have made a mistake, my lord. I have wrongly annexed order, which for to be my lord, the IA number 91 of 2024, but some mistake, it was IA number 91 of 2025. So this is the order, my lord. My lord can be aware of this man. In body, my lord correctly mentioned, my lord, when I annexed the order, last order in IA, that was by mistake, my lord.
IA number?
IA number, my lord, I annexed IA number 91 of 2025, but in actually IA number 91 of 2024. Due to year mistake, my lord.
No, in the cost title you have mentioned it as?
Correctly mentioned, well, 91 of 2024.
Okay.
In body also correctly mentioned, but when I annex, that is my lord
Okay.
wrong.
Heard Mr. G. Utin, learned counsel for the applicant, and also heard Miss
M. Psychology.
M. Saikia, learned counsel for the respondent, opposite party. This interlocutory application is preferred by the applicants. Namely, there are 6 applicants.
Yes, my lord.
6 or 7?
That's my lord, seven, my lord.
7.
Yes. Some were my lord, minor, so mainly represented by one, my lord, Moinul Haq.
6 claimants, Lordship.
6 claimants.
7 and 8 are owner and driver. And 5, 6 are minors.
Oh, minor, yes.
No, their ages are 25 and 20. How can they be minor?
I do.
Earlier they were
Earlier.
in the minors.
Earlier?
Now,
6 applicants, right, for allowing them to withdraw 50% of the awarded amount.
my lord, that is 10 lakhs,
10
63,300.
lakhs?
63,300.
Ten lakhs 63,000 300 rupees.
300.
Before the registry of this court. From the registry of this court. Mr. Uddin submits that person to order passed by this court in IA number 91 of 2024. The respondent opposite party hearing had deposited is sum of rupees deposited 50% of the awarded amount before the registry of this court, and the applicant may be allowed to withdraw the said amount from the registry of this court. Is the case submits that any objection? No objection. Submits that she has no objection in the event of allowing the applicants to withdraw the appropriate amount from the registry of this court. Taking note of the submission of learned counsel for both the parties, this interlocutory application is then allowed, allowing the applicants to withdraw the 50% of the awarded amount deposited before the registry of this court.
33.
It pleases your lordship. My lord, here, erstwhile I was appearing for the sole respondent, my lord. But the respondent expired, my lord. So as of now, I don't have any instruction, my lord, to appear. Otherwise, they filed 3 petitions, substitution, setting aside abatement, and delay condemnation, my lord. Notices may go, my lord, to the.
Notice.
Notices may go to the.
Heard Mr. Islam, learned counsel for the applicant, and also heard Mr.
A. Rekha, my lord.
A. Rekha, learned counsel for the respondent. This application under Section 5 of the Limitation Act 1963 is referred by the applicants for condonation of delay of 304 days in filing the application for substitution of legal heirs of the opposite party in RSA number 125 of 2020. Is Decker submits that the sole respondent, namely Abdul Matlib suffered demise, and he has no instruction in this regard, and as such, he contended to issue notice to the legal heirs.
Yes.
Legal heirs of the respondent, sole respondent. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the legal heirs of the respondents, sole respondent, namely Abdul Matlib, fixing the matter after 4 weeks. Step be taken by registered post with AD and also by usual process within from today.
In main case, opposition to 5 candidates. In main case, main appeal, we kind of. Opposition to 5, report was called for 1, but it has not received. Remainder,
Oh, have you furnished the particulars of the respondent?
Yes, yes.
Furnished?
Yes.
When? Received it?
Yes, my lord. And after that, they filed the preferred the applications, my lord.
So, whether any order is required to be passed in RSA?
Not record was called for, but it was not received. Reminder may be given to the state. RS appeal admitted and record was called for.
Money should number not received. Money appeal.
9823 notice appeal admitted and elsewhere was called for.
Okay. Heard Mr. Islam, learned counsel for the appellant, and Mr. Dekka, learned counsel for the respondent, sole respondent. Mr. Dekka submits that person to order of this court dated 17/3/2025. He has furnished the particulars of the legal representative of the sole respondent to Mr. Islam, learned counsel for the appellant. Mr. Islam submits that as per office note dated 2/5/2025, LCR relating to money suit number 12 of 2017 has not been received from the learned trial court. So the LCR of money appeal number 3 of 2022 has been received. Accordingly, it is provided that registrar will issue reminder to the learned trial court to transmit the record of money suit numbers, etc. So without further delay. Please suffer for weeks. Public.
My lord, this is file under order 39 rule 1 and 2, it's section 151 CPC, praying for and passing an order of injunction, my lord. What happens, my lord? It is a stay order in spite of the stay order passed by the honorable court. That is page number 11, my lord. While the RSF was admitted, my lord, the opposite party is blocking the road of the petitioner, my lord. And admittedly, the petitioner is staying backside of this suit land, my lord. And this suit land, because of that, the suit was dismissed. In the trial court, they now try to occupy the whole land, suit land, and thereby blocking the road of the petitioner, my lord. It is very much essential, my lord. I cannot go and out from the egress and outgress is blocked. So interim order may be passed and they may be allowed to file their objections. Lordship will find it is admitted fact, my lord. The para page 13, my lord. Page 13. In the middle of the, it is an counter affidavit, not counter, it is an affidavit, counter claim, actually, written statement on counter claim filed by the petitioner, my lord. Here they have admitted, my lord. In the middle, from the middle page, my lord, the page number 13. The principal defendant number 1 sold 1 bigha 3 kotha 0 lesa from the said Dak Pata to Musammad Sanas Khanam. That is the petitioner. The performer defendant number 5 by registered shall deed number such and such, and its boundary is such. North, plaintiff and the portion of the land of principal defendant 1. South, Sorkari land. East, land of Dak numbers 133, PP number 155. West, land of principal defendant number 1 and some portion. It is very important, my lord. And some portion of
okay, Mr. Popon, okay. Yes, why there is a stay order operating. Person to order dated 22/11/2021.
Yes, Your Lordship.
Why you have blocked the road?
And 3 weeks time may be granted to file our affidavit in opposition.
So no, there is a pair for temporary injunction. But if your road is already blocked, then
my lord, road there, this photograph shows that I can go by walk, my lord, but not it is motorable, my lord. My land is in the backside of the suit land, my lord. This photograph is clear, my lord. They take some earth, stone, etc., my lord, blocking my road, my lord.
Have you seen the photographs?
Yes, Your Lordship. Lordship, actually, I'm appearing on behalf of my senior N. Goswami, and I have only been instructed to take
senior
N. Goswami. So I've been only instructed to take 3 weeks time to file a petition in opposition.
Not 3 weeks. How there will be ingress and outgress of the applicant hearing?
Admittedly, my land is
1 week or 2 week time may be granted. After that, let the matter become.
Okay, 1 week then.
My interim may be granted, my lord. Otherwise, I cannot enter into my land, my lord. Interim may be granted, my lord. Let them allow to file their affidavit, my lord. But interim may be granted, my lord.
No, interim means your road is already blocked.
Then block means, my lord, it is photograph. I can go, I am to go my land, my lord, by walking, whatever it may be, my lord. I am to go there, my lord. If they are doing these activities, then they will completely block the road.
If we just look into page number 11, title should tell remain state will disposal of the appeal, but there is no injunction as such.
Injunction was not there, stay was there.
yeah.
That's why I pray for injunction.
Only 1 week time may be granted with my senior come and do the lordship.
Art, Mr. This is a open learned counsel for the applicant and also Art Mr.
Yes, Soikia.
Yes,
Soikia.
Soikia, learned counsel for the respondent.
Respond number 1.
Yes,
Only respond number 1.
This application under order 39 rule 1, 2 and 3 related section 151 of the Code of Civil Procedure is referred by the applicant for granting an interim stroke temporary injunction against the respondent opposite party. Mr. Pupul, learned counsel for the applicant submits that the applicant herein has preferred RSA number 111 of 2021 against the judgment dated 31/3/2021 passed by the learned civil judge Moreno in title appeal number 11 of 2018. And this court, while admitting the aforementioned appeal, state the judgment dated 5/7/2018 passed by the learned Munship number 1 in title suit number 23 of 2014 till disposal of the appeal. But hereafter, the respondent opposite party blocked the road leading to the residence of the applicant. And as such, there is a requirement for granting ad interim, granting temporary injunction, restraining the opposite parties from further blocking the road leading to the residence of the petitioner. The learned counsel, Mr. Soikia, learned counsel for the respondent submits that 1 or 2 week time may be granted to the respondents to file their objection. There is accordingly allowed, however, taking note of the submission of Mr. Pupul, learned counsel for the applicant, and also going through the Annexure 3. Annexure 3 series at page number 17, 18, and 19 of the application. This court is inclined to grant injunction, temporary injunction. The inclined to direct the parties to maintain status quo. Till next date. Till next date, list the matter after 2 weeks.
Oblige, my lord.
Status quo will serve your purpose.
My lord.
Status quo will serve your purpose.
It will serve, my lord. One direction may be given to protect the order by the police, my lord. One direction just. This order may be protected by the police. Otherwise, they are doing, again, they will do these activities, my lord.
Order may be
protected, my lord, by the police, my lord. O.C. Morigao, my lord.
But such kind of direction is required to be issued here.
My lord, if a copy is to be served to the police, then they will look after the matter, my lord. Otherwise, they will not follow the order, my lord. They will again do this, my lord.
Okay, Mr. Pupul, learned counsel for the applicant submits that a copy of the order maybe furnish, no, maybe transmit it to the local police station, to the officer in charge local police station.
For protection of the order, my lord.
For protection of the order, there is accordingly allowed.
My lord, one affidavit is filed in the main RSA, my lord. In the RSA, affidavit is filed admitting the this RSA, my lord, filed by the appellant, my lord. Puddar is there, my lord. He filed this affidavit, my lord. Puddar is in the busy in another court, my lord. Sunil Puddar is there, my lord. He filed this affidavit. He supported the case of the appellant.
Who filed the affidavit?
Sunil Puddar, my lord, he is an advocate, my lord, and this is Bijay Kumar Ladha, my lord. He is the respondent number 2, my lord. Performer respondent number 2. He
Where is the
supported-
affidavit?
Affidavit is in the record, I think. It affidavit এটা ফাইল কৰিছে মই পাইছো কপি পাইছে না হয় the learned opposite party also received the copy. One affidavit is there.
When it was filed?
My lord, it is 1/5/2025, I think. As I received this copy. একটা রেখে পাচ্ছি না একটা রেখে আছে কপি পাইছে মই ৰিচিভ কৰিছিলো আপুনি পাইছে এই ৰিচিভ দি কপি মাৰিব
But it is not available on the record. There is no
Okay.
office note also.
Okay, next step, my lord. I will bring it to the record, my lord.
Okay, heard Mr. DCC, Gopal, learned counsel for the appellant, and Mr. Soikia for respondent number 1.
Rest are already ex-party, my lord. The justice service was served upon the rest respondents. And they have not appeared, my lord.
So earlier, N. Goswami appeared on behalf of the respondent number 2 also.
No. Some other advocate is there. Respondent number 2. Bijay Kumar Ladha.
Miss,
Miss, yes, Gogoi. Jutika Gogoi. She was appearing.
For respondent number 2.
Respondent number 2. And now fresh Sunil Puddar has filed the Ukalatnama here, madam.
So as agreed by learned advocates of both the parties, recessal is the matter on after 2 weeks.
Problem.
Item numbers 35 to 44.
My lord, these are all land acquisition appeal from common judgment. And I have two prayers, my lord. First of all, there are two items where one appellant died, substitution petition is there. Number 1483, in this case, IA number. I. Appellant number 3 died, my lord, and it is substitution petition is within time. So substitution may be granted.
Heard Mr.
DK Nath.
DK Nath, learned counsel for the applicant, sir.
KK Bhattacharya for respondent number 1.
Respondent number?
For respondent number 1.
Respondent number 1.
Right.
And for rest of the two respondents?
Lordship and
You are for?
2 and 3.
2 and 3, Mr.
SS Roy.
SS Roy.
My lord, the notices has the 10 cases are there. The notices has not been served in all the to all the parties, and there is some confusion because we are not getting the main appeal. The only the IAs we have got.
This was of 2019, my lord, appeals.
The cases
And
are
at-
coming after 6 years.
At that
So there
time,
is some confusion.
at that time, notices were served. If my lord insists, I can serve extra copies, no problem. I can serve extra copies.
Okay. This interlocutory application under Order 22, Rule 1 and 2 of the Code of Civil Procedure is referred by the applicant for substitution of the legal heirs of appellant number 3, namely Arup Sharma, who suffered demise on 22nd of March 2024. Mr. Nath, learned counsel for the applicant submits that appellant number 3, Arup Sharma, suffered demise on 22/3/2024, leaving behind one Srimati Kamini Devi. Kamini Devi is the wife.
Yes. Please, number 3, ma'am.
Kamini Devi, wife of the appellant number 3, and Sri Jitul Sharma, son. Jitul Sharma, son of the appellant number 3, and they are required to be substituted in place of Arup Sharma. Mr. Procedural and Mr. Roy submits that. Any objection?
No, we have the instruction lodging because it come after so many years. After 6 years, it has come.
Substitution is actually, there is no delay in substitution. So that may be allowed.
Stated for objection, if any, then lordship, today is
If
the first
any.
time. Today is the first time.
Okay, Mr. Procedural and Mr. Roy submits that. Since the matter has been listed after 6 years, they may be granted some time to obtain instruction. Here is accordingly allowed. Recusal is the matter after 1 week.
Okay. 2 weeks. After 2 weeks.
After 2 weeks. After 2 weeks.
Petitioner will serve the copies. Extra copies.
Okay. Mr. Roy submits that. He has not been furnished with extra copy of this interlocutory application.
Yes.
You received?
Yes, we have not been served with the appeals also, man.
No, you have received this IA.
The IA we have received.
Okay.
State of Assam.
Accordingly, it is provided that Mr. Nath will furnish a copy of this interlocutory application to Mr. Roy during the course of the day. Mr. Procedural further submits that he has not been served with the memo of appeal number
All the 10 cases.
of all the land appeal number 10 2019 to 2000
10, 2019, 4, 2019, 5, 2019, 7, 8, 9, 10, 11, 12, 13, 14, 14.
Accordingly, it is provided that Mr. Nath will furnish copy of memo of appeal and the relevant documents to Mr. Procedural and Roy. Today
Not
or
today, my lord. I have to xerox all the copies.
within 2 working days from today.
Tomorrow, yes. Yes. My lord, may I pray for another thing? Actually, these appeals were prepared in the year 2019. And initially in the land acquisition matter, amount of rupees 5,81,000 was given, which was enhanced by the learned district judge up to 70,000, 7,50,000. 2 lakhs or 2,50,000 difference, but that enhanced amount yet not been paid by the, my lord, respondent number, the defense department. And when I personally visited the defense estate officer Tezpur, they insisted that you withdraw the appeals, then only we can pay the amount. So direction may be given to the defense authority, respondent number 4, to 3, to pay this undisputed amount. I am not saying that appeal would be, when appeal would be decided, further enhance would be done, but enhanced amount should be.
Better you file on IA. Let them obtain instruction.
Madam.
Then we will discuss.
My lord, one more thing is there, they are not in revision, they are on appeal. What I have learned, my lord, in appeal, the court has also the power to reduce the amount. So let the case be, make some progress at least. After that, these things will come. Because this is appeal. If this is a revision, I would
heard by me, claimants.
Because when I appeal, the court has the power to do reduce.
Okay, we'll see if we file an application to that.
So we may also have a view to wait until the bill is over.
Item 46.
So this matter has come up for the first time, my lord. I pray, my lord, notice may be issued upon the response of opposite parties and the opposite parties, my lord. There is also a connected case, but right now let the notice be issued to the opposite parties, my lord.
Heard Mr. Kaun, learned counsel for the applicant, and Mr. Roy for respondent number 7 and respondent opposite party number
7 and 9.
7 and 9. 7 and 9. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant, Meghalaya Transport Corporation Limited. No, not limited. Meghalaya Transport Corporation for condonation of delay of 1,478 days in preparing the connected regular first appeal against the judgment dated 17/4/2018 and the decree dated 3/5/2018 passed in money suit number 79 of 2006 passed by the learned civil judge number 1 Kamrup M. Guwahati. Guwahati. And now civil judge senior division number 1 Kamrup M. Guwahati. Where is the application and the documents enclosed there? Let notice be issued to the respondent number 1, 2, 3, 4, 5, 6, and 8.
8 and 10 also.
8 and 10. 8 and 10. By registered post with ADN also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 7 and 9 since Mr. S. Roy, learned standing counsel CGC entered appearance and received notice. However, extra requisite copy of the application be furnished to Mr. Roy during the course of the day. Please the matter after 4 weeks.
Yes, ma'am.
47.
Lordship, this is a delay petition, first time listed lordship. Delay of 60 days, lordship. I think notice fee.
Heard Ms. R.D. Mazumdar, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 58 days in preparing connected appeal against the judgment and award dated 23rd/7/2024 passed by the learned member Motor Accident Claim Tribunal Nagaon in MSC case number 190 of 2020. Where is the application and the documents lesson record? Let notice be issued to the opposite party by registered post with ADN also by usual process within a week from today. Place the matter after 4 weeks.
Highly obliged.
My lord,
yes.
I have forgotten to make a prayer in my earlier case, item number 5. Your lordship was pleased to issue the notice and also elsewhere call for. But the proceedings also may kindly be suspended, my lord. There is a prayer.
We'll see. If possible, we will do it.
My lord.
We'll examine the matter.
All right.